Sir at the jail, can you tell me your name, please?
Alex Stouffer.
Mr. Doper, okay.
Welcome back, everyone, and brace yourselves, because today's courtroom session is a collision of missed court dates, child support warrants, financial fallout, and two defendants fighting to explain what went wrong. From claims of lost mail and family medical emergencies to emotional appeals about jail conditions and burned bridges with employers, this video is packed with tension. You're about to see judges who are firm, attorneys who are trying to make sense of the chaos, and defendants who are hanging on as second chances by a thread. Stick with us. This hearing moves fast, and every twist matters.
On the record in People versus Alex Doper, this is file number 256896 and 6895. The record should reflect Mr. Doper's appearing today by video from Otsego County Jail. If I could have both counsel put your appearances on.
Good morning, Your Honor. For the record, Mike Roll on behalf of the people.
Larry Brown on behalf of Mr. Doper.
All right, Mr. Doper, you're before the court today because you failed to appear for a hearing in each of your files here in circuit court back on October 20th of 2025. The court issued a bench warrant based on that failure to appear. Do you understand why you're before the court today?
Yes, sir.
All right, Mr. Brown, have you, it looks like you're Mr. Doper's counsel of record. Did you have an opportunity to speak with him prior to this hearing today?
I did, Your Honor. He gave me some information. I believe his fiance sent me some information that he did not get mail. I did review that. She actually called my office. I spoke with her. I don't think that is necessarily going to help him out too much in this particular hearing, so I'm not sure how he wants to proceed at this point. We are going to need an update on the record too.
Okay, Mr. Brown, I guess one of my questions, because in looking at the paperwork that I got for the hearing today, it looks like there was also an FOC bench warrant for Mr. Doper. Is that correct?
Yes, Your Honor.
Okay. All right. So, and it looks to me like based on that Mr. Doper is going to be, he either needs to make $1,000 payment or he's got to do 30 days in jail. Is that correct?
I believe so.
All right, Mr. Doper, as to the friend of the court matter, which is separate than the files that we're talking about today, but are you going to make that payment or are you planning on serving that 30-day sentence from the friend of the court warrant?
It looks like it's like a $4,000 payment. There was 4 warrants for child support.
Okay.
There was 2 $1,000 ones, and I have no clue, Your Honor. I really don't. I'm going to try to make them.
Your Honor,
I really don't have the means.
Okay. Mr. Brown, go ahead. Was there something you wanted to say?
I think those, I was going to say there may be some in district court as well, but those may be the FOCs.
Okay. All right. So it's my intention at this time to order that Mr. Doper's bond remain in these 2 files remain revoked. The court is going to set this for a status conference at its next date, which I think would be probably next Wednesday or next Monday. For a status conference in these felony files. It's my view that based on what Mr. Doper's indicated that he's more than likely going to be remaining in jail on the FOC warrant. So I think that the bond decision here is largely irrelevant, at least for the next 30 days.
Your Honor, is there any way I can get a bond on that? Because I might be able to bond out. Like, to do no bond on it is just kind of silly, I think.
Well, you not showing up for your hearings is kind of silly too. So
no, I understand that, Your Honor. And if my lawyer would explain to you what happened, I'm sure that you might,
I mean, honestly, it doesn't matter what he says. You weren't here. there's no good reason for you not being in court when you're supposed to be in court. So
Okay, can I explain for myself then, Your Honor, instead of my lawyer?
you can, but it's not going to matter. But go ahead.
Okay. Okay. Well, I would still like to explain for myself. My father has had a stroke. I was downstate. I got wind from my attorney that I had a warrant out for my arrest for missing court. I contacted him. I told him, I said, hey man, he said that I had court coming up. I said, hey, I'm downstate with my father. If there's any way that you can get this matter adjourned. He got back to me, said that it didn't have any effect, which that's fine. The main thing is that my mail's not going where it's supposed to be going, Your Honor. I have text messages proof that my ex-girlfriend's been getting rid of my mail. It's not that I got the mail and I knew that I had the court date and didn't show up, Your Honor. I didn't know. I was downstate with my father, man. This is not like some intentionary, I'm out here trying to evade you or not take care of this problem, Your Honor. This is serious to me. I put up a $10,000 truck on my bond. Like this isn't a joke, and I'm sorry that I wasn't here. I just don't think that the situation is lit and everybody's seeing what's going on. I mean, it was literally a miscommunication and a genuine accident.
Your Honor, if I could.
Go ahead.
Sorry. I did get those text messages that Mr. Doper is talking about regarding his mail. He does have some mail going to a different home. He does have some mail going to, from what I could figure out, at least 3 separate addresses. I don't know if maybe he thinks if he updates one court with an address that they just call everybody and update everybody else. But I did advise
I've
that
given you guys the address, and I've given that court the address too. Everybody has the proper address. I don't live at 336 West Main. I don't live at P.O. Box 55. I don't live at 16920 South States Highway. I live on Leland Trail. That's the address you guys have. I provided that.
Yeah, either way, regardless, it's your responsibility to know when your court hearings are. If you don't get mail, to call the court, find out when your next hearing is, to call your lawyer, find out when your next hearing is. It's not our job to chase you down and figure out which address is the right one out of the 4, however many addresses you have. It's not our job to make sure your ex-girlfriend or your girlfriend gives you your mail. That's not our responsibility. Our responsibility is to schedule your hearings, to send out notice to the best address we have, and then the rest of it's up to you. That's why none of that is an excuse, and that's why I told you at the beginning.
This is where the courtroom tone really shifts. Alex insists his mail was mishandled by an ex-girlfriend and scattered across multiple addresses. But legally, the judge is absolutely right. Keeping track of your court dates is the defendant's responsibility. Judges expect you to call the court or your lawyer, especially if you've had problems receiving mail before. Notice how the judge's patience tightens as the address confusion grows. From her viewpoint, this wasn't a one-time slip, it was a pattern. And in the legal system, patterns matter. What do you think? Is Alex being genuinely misunderstood here, or is the judge justified in holding firm?
None of it is a reason for me to change anything about your bond. So that's why we're going to go forward. I want to make sure you're here for that next hearing, and the only way to do that is to make sure that you're not out of jail at this point. So the court's going to deny bond until that next hearing date. We're going to get you scheduled as quick as we can. Again, I said, it'll be within the week. And we'll go forward with your case at that time. So that's the order of the court as to this file. Mr. Rolla, is there anything that you needed to address for the record on either of these files today?
No, Your Honor, thank you.
Okay.
Judge,
Right,
would you like us to update his address? I do not have the Leelanau address.
Yeah, we can do that through the jail. If
Okay.
you want to fix with the jail. I don't want to put. Okay.
Thank
you. All right, thank you. That's all for this hearing today.
All right, Mr. Doper, there are 3 cases. Let me give those, put those on the record, and then we'll move forward.
First is State of Michigan versus Alex Dopefer, file 21-39869-ST-3. Next is file 23-42248-SM-3. And then finally, we have file 19-37559-ST-3, all set for bench warrant arraignments. Mr. Dopefer, my name is Judge Hesselink. I'll be arraigning you on these criminal matters. And then the attorneys will be assisting me with those. All right, in file 19-37559, Mr. Dopefer, it appears that there is unpaid payments in the amount of $240 and no payments have been made. You understand the nature of the allegations in that file? Mr. Dopefer, do you understand what I've just said to you?
Hold on, Your Honor, I didn't hear you. Let me turn this up a little bit. What was that?
I said there's in the first file, the oldest file, file 19-37559, there's $240 in unpaid criminal payments, and you failed to make those payments. Do you understand the nature of the allegation?
Yes, sir.
Failure to make your payments it would be a contempt of court charge, would carry a maximum of 93 days and or a $500 fine. Do you understand the maximum penalty?
Yes, sir.
All right, in file 21-39869-ST, the allegation is that you failed to appear for an order to show cause on 10/17/25 on the underlying charge of driving with your license suspended, failure to stop at a scene of an injury accident, and operating without security. Bond has been set at $1,000 cash or surety. Do you understand the nature of this charge for failure to appear on 10/17/25?
Yes, sir.
All right, failure to appear, contempt of court, also has a 93-day penalty and up to a $7,500 fine and cost. Do you understand maximum penalties for that?
Yes, sir.
All right, in file 23-42248-SM, the allegation is that you failed to appear for an order to show cause on 10/17/25 on a charge of domestic violence, and bond is set at $4,000 cash or surety. Do you understand the nature of the allegation in that file?
Yes, sir.
And do you understand the maximum possible penalty could be up to 93 days in jail and up to a $7,500 fine for contempt of court?
Yes, sir.
All right, as to each of these files, you have the following rights. You have the right to have a contested hearing. You do not have the right to have a jury trial because these are contempt matters. You'd have that right to have a hearing in front of me as the judge. At that hearing, you could see, hear, and question the witnesses against you. You could get an order from the court requiring those witnesses to appear and testify. You could testify or you could remain silent, and that silence could not be used against you. You have the right to have the burden of proof beyond the prosecution or the probation department at all times, and that proof would be by preponderance of the evidence. That's 51%, and you'd have the right to appeal. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
Yes, sir.
All right. Do you wish to have an attorney represent you as to each of these files?
Yes, I do.
Mr. Truce, have you had an opportunity to speak to Mr. Dopefer about his right to an attorney?
I have. He would qualify for appointed counsel. He's previously qualified, and Mr. Brown is representing him. I also would indicate from what he's indicated to me, I think he's sitting on a 30-day jail sentence, so that likewise would qualify him.
All right. Is that what you want to do, Mr. Dopefer, have court-appointed counsel?
Yes, sir.
All right. I will appoint an attorney for you. That information will be sent to the administrator of court-appointed attorneys, and he will likely use Mr. Brown, although I can't guarantee that. So I'll enter a not guilty plea on your behalf in these files so that you have an opportunity to speak to Mr. Brown before you decide what to do. We will reschedule this matter. Yes, we should have first week of November. So Thursday?
That would be Friday. I believe it's the 7th.
All right, Mr. Doper, I'm going to reset this for, morning or afternoon?
Morning docket.
All right. For November the 7th, which is a Friday at 9 a.m.
Thank you, sir.
All right, I'll see you then. Thank you, sir.
Thank you. Ross.
Huffman, Stanley.
All right, Mr. Huffman, let me call your case. This is in the matter of Danny Marcinkowski and Stanley Huffman. That's file 2017-016885-DP. Mr. Huffman, my name is Judge Hesselink. I'm coming to you from the district court. With me in court is a representative of the friend of the court, Ms. Kraus. And on the Zoom call is Mr. Trusch, acting as defense counsel. The allegation made against you today is that this is a bench warrant arraignment, is that you failed to appear on or about October the 10th of 2025 for a friend of the court child support matter, and that a bond in the amount of $2,200 was given to you for your failure to appear. Do you understand the name of the allegation made against you?
Yes, Your Honor.
The penalty for such a violation could include jail time up to 93 days and or a $7,500 fine if you're found in criminal contempt for that. Do you understand the penalty
Yes,
for
Your
that?
Honor.
All right. Your rights as to that hearing include the right to be represented by an attorney, the right to have a trial or a contested hearing in front of a judge. You do not have the right to have a jury trial, the right to see, hear, and question the witnesses against you, the right to present your own witnesses and get an order from the court called a subpoena to require those witnesses to appear and testify. You could testify, and the burden of proof would remain with the friend of the court's office to prove that you failed to appear, and you'd have the right to appeal. You understand those rights?
Yes, Your Honor.
Do you have any questions about those rights?
No, I do not.
Do you wish to have an attorney represent you?
I think so.
All right, Mr. Truce, do you know if he qualifies for court-appointed counsel?
Yes, Your Honor, he will qualify.
All right. All right, Ms. Kraus, could you remind me of how this case is currently, what the status of it is currently?
Yep. I hope you can hear me well enough. The history of the case is back from February 6th, where there was an arraignment when he failed to appear, and bond was reduced to $500 and adjourned to May 23rd to address contempt. At that hearing, he did fail to appear, but an income withholding was active and it was adjourned out to August 22nd. And our office was to prepare an ordered on arrears petition. That was heard on June 27th. He failed to appear. Commencing July 1st, we were to collect monthly $536, composed of $378 for current support, $158 for overdue. And then the hearing from August 22nd, he failed to appear again, but the income withholding was collecting and was adjourned to October 10th. At that hearing, he failed to appear again. The income withholding stopped collecting, and then the bond was issued in the amount of $2,200. The arrearage balance is $8,398.44.
All right, Mr. Huffman, did you hear all that?
Yes.
All right. What happened with your income withholding order? Why aren't you making your payments?
I mean, obviously it doesn't go with this case, but obviously, I've been having some money problems, and it's been hard to hold a job. It's not really hard to hold a job. It's just I've kind of burnt my bridges when I was younger, and it's really hard to find a job for me around here. No, that's nobody else's excuse but mine. I take full accountability for that. And I take full accountability for not paying the child support. It's not that I don't want to pay it, and it's not that I want to miss court, because I don't. I preferably rather just deal with the court and just head on, not try to avoid it. And for money wise, it's really hard to, adulting it's hard. Obviously, as we know, it's I can't hold a job to save my life, and I'm trying, and I'm trying to change my life better than what it used to be. I don't want to live the life that I used to be. And let me tell you, 2 days being in this jail, I'm good. I'm good. I mean, I used to do all the time in the world, but no, I'm good. I'm over it. I'm good. I don't want to be in trouble no more. You got a girl down the cell screaming at the COs. You got people freaking cutting their nails in the night, and I'm all right. I'm okay with this. I'd rather just pay my money and be on my way and follow the law.
So how do I get you to do that, Mr. Huffman?
I know it's asking a lot, but give me one more chance to start paying on it, and I know I have a construction job set up for once I get out, but I didn't want to set up the construction job until after I did my couple days in jail. That way I didn't mess up my chances with him. Allow me to try and keep making payments. Because I'm good on jail. I promise you. I am good.
Well, here's the deal. We started this process back in February. And when you had your income withholding orders, we kept bouncing it out so that you could continue to make your payments. So we did that to May and to August, none of which you showed up for, but we still gave you a break and said, all right, he's still making his payments.
Now we shift to Stanley, whose tone couldn't be more different. He's candid, emotional, and clearly shaken by jail, which can affect how judges perceive sincerity. But child support enforcement operates on structure, not sympathy. The friend of the court explains how they repeatedly extended deadlines because wage withholding was working. When those payments stopped, the system had no choice but to escalate. Stanley's plea is heartfelt, but look closely. He admits to burning bridges with employers, struggling to stay consistent, and ignoring mail. The judge's frustration isn't personal, it's procedural. Still, this raises a big question. Should emotional honesty outweigh past noncompliance?
Even though he's not showing up when he's supposed to, he's making his payments, but then the payments stopped. And we had to come find you because you didn't just come into us and say, hey, I'm having a hard time working. Can you work with me? You just blew us off. So here I am. I got your attention now, and you're asking me for a break, even though we've given you breaks for the last 8 months.
It's not
go ahead.
that I didn't want to show up for court, so I apologize. I do apologize. It's not that I didn't want to show up for court. It's not that I didn't want to make the payments. It's just I did not have the money. I've been forking out. I've been trying to keep up with all the bills I have, and obviously that's adulting life, and I know I have to learn that by myself, and I know I have to take accountability for that. And I am trying very hard to stay up on my bills. That's just I only work 3 days a week with the one job I have. And I have money for when I get out to post some bond. Not a lot, but I do have some money, and I have been going to jobs or interviews. I went to Mishaway about 2 weeks ago. They haven't called me back, so I'm gonna guess they don't need me. But I do have a construction job that Officer Keller had set me up with, so I'm hoping that will help out.
So other than construction type jobs, what are you applying for?
Cooking, inside work, office job work, honestly anything I can get my hands on.
I see help wanted signs at the fast food industries all over town.
I kind of burnt my bridges on a lot of those when I was younger, and that's why it's so hard for me to find jobs now, and I know that's my fault. I burnt my bridges out with a lot of jobs when I was younger. And Truce has been dealing with me for years after years, so I'm sure he can somewhat see that. And I regret burning my bridges. I do. Believe me, it was dumb. I was young and stupid. I regret a lot of my decisions, and I do not want to become that person or be that person anymore. I want to continue with life and show the court that I can do right, and along with my family, and for me and Danny Lynn's kid, our kid.
Let me have Ms. Kraus make one other statement. Go ahead.
we would still be requesting contempt because his inmate questionnaire indicated he has been working 3 days a week. He did indicate he was paid on Monday, but he still hasn't paid out of any available resources. So we would request the bond to continue and have a hearing.
Mr. Huffman, have you got any money to pay anything right now?
I do, but it's not in my pocket. It's at the work. I would have made a payment. I promise you I was gonna make a payment, but I got locked up before I could even get my money. If you can give me Thursday, give me when I get out. If you guys allow me to get out, could I please make a payment to you guys?
What's wrong with your ability to make a phone call?
Because it's not, I don't know if they will release the money to my girlfriend.
Is it yours or is it still not owed to you yet?
It is mine. It's over at Lisa's Tavern.
Then call Lisa's Tavern and say, give it to Mrs. X or Miss Y or whoever you want to send over there to pick it up. And they can make a payment for you, right?
Okay. I can
How much
pay
money-
like $250 if that will suffice for now.
That's not much. You owe $8,000.
I know. That's all I have right now. I apologize. But allow me to keep working and paying it off, and I can do that, and I promise you I can. I know I've showed the courts before that I wasn't showing up. It wasn't that I wasn't trying to show up. It's just I wasn't paying attention to the mail coming in, and I didn't see all the court dates. And I apologize for me missing court and not paying. It's not that I don't want to make the payments because I do want to follow the court.
All right. I've heard you, Mr. Huffman. I've heard you. Here's what we're going to do. Once the friend of the court receives a payment today, if they receive a payment and when they receive a payment, then we will reduce your charge to a PR bond. Right now, it's going to stay at what it is, which is $2,200 cash. But if you come up with $250, I'll reduce it to a personal recognizance bond, and we'll set it for a hearing in 30 days. As long as you're making your payments within that 30-day time period, we'll just keep adjourning it out, and we'll see if you can make a habit of making your payments. If you get another job and you can do another income withholding order, that'd be great. But otherwise, you're responsible for making your payments. You understand what we're doing?
Yes, Your Honor.
You have any questions about that?
No, Your Honor.
Ms. Kraus, do you have any questions?
I would just ask for him to contact our office and get a good contact number once he's released.
You understand that, Mr. Hoffman? Yes.
Yeah. I was wondering if, because the CO asked me to ask this along with it, if the 4 days that I was supposed to start, could we have started that yesterday?
Free credit for time served, is that what you're asking about?
Yeah. Yes, Your Honor.
Yes.
Okay.
You were picked up. I'll give you credit for whatever time you're entitled to on that. And the faster you get somebody over to the friend of the court's office making a payment on your behalf, the faster you get out of jail.
Thank you, Your Honor.
Do you know who's going to show up at the friend of the court's office?
Yeah, my girlfriend, Brooke Keene.
Brooke, what's her last name?
It's
K-E-N-E.
All right, thank you. All right.
Thank you.
As soon as she shows up with the $250, the friend of the court will prepare the appropriate paperwork. I'll sign it and get it over to the jail, and we'll get you out of there.
Thank you, Your Honor.
Stanley,
All right.
when you get out of the jail, call my office.
Yes, James, I got you. Thank you.
He is sitting on a 4-day sentence right now.
Yep. So I can't change that, but I can get him out on mine.
And that wraps today's hearing. We watched two very different defendants face consequences not for new crimes, but for missed obligations, court dates, child support, and communication breakdowns. Alex's situation shows how quickly bond can evaporate when the court feels a defendant isn't staying engaged. Stanley, meanwhile, earned a conditional path forward, but only after making a payment and demonstrating real commitment going forward. These cases highlight a core truth of courtroom life: consistency, reliability, and communication can make the difference between freedom and custody. If you found this breakdown helpful or eye-opening, hit that like button, drop a comment with your thoughts, and don't forget to subscribe for more real courtroom insight and analysis.
Thank you.
Thank you. Anyone else, Your Honor?
No, I think we're good for today. Thank you.